Okay, let me just again stop something here. Why does it do this every time? Right. Okay. If the business rescue is commenced by an order of court, the court appoints an interim practitioner, who must be nominated by the applicant. But this appointment is subject to ratification by the majority of independent creditors. So it's just a simple majority, 50% plus one, of independent creditors. But remember, the vote is based on the value of their claims. But independent creditors at the first meeting. This is the absolutely only instance in Chapter 6 where a business rescue practitioner can be removed without an order of court. So if the independent creditors refuse to ratify the appointment of this business rescue practitioner, they may nominate somebody else, and they don't need a court order for that. Now, CIPC Note 20 of 2022 has got a whole list of requirements, filing requirements, when a business rescue practitioner is appointed, and the CIPC, as you will remember, the notice of appointment must be filed with the CIPC, and there is a whole host of requirements that have to be met. Among other things, a certificate of membership in good standing of the professional organization to which the business rescue practitioner is a member of, or to which he or she belongs. And it's very important to take note of that, to note 22 of 2022, because otherwise the CIPC will refuse to accept the appointment of the business rescue practitioner. And it doesn't matter whether this appointment is by the board, by the court, you still have to comply with all those requirements. Qualifications for a business rescue practitioner. Judicial managers did not have to have specific qualifications or professional affiliations, and there was no specific provision for their removal. In the case of the business rescue practitioner, the intention was really to create a special profession subject to a specific statute so that you could avoid the corruption that, or the allegations of corruption that were sometimes leveled against liquidators. This has not worked out because the drafters of the Act forgot to create by statute a regulatory authority, which you need if you want to regulate the specific profession. So instead, they went for two qualifications. The one is that the CIPC must license a person to act as a business rescue practitioner. Again, the CIPC has published a whole list of qualifications. They actually take you through the steps for being licensed as a business rescue practitioner on their website, plus all the requirements to be appointed. It is quite a process, but once you've been licensed, I think the duration of the license is 3 years, if I remember correctly. And then the other main requirement is that it is subject to membership of an accredited professional body. And that is one of the things you must prove when you apply for a license. There are currently 12 or 13 of these accredited professional bodies, like the Turnaround Management Association, SARIPA, SAIPA, SAIBA, and also the Legal Practice Council. Although I think that the CIPC has sometimes regretted accrediting the Legal Practice Council, because one of the requirements for accreditation is that you must be able to discipline your members if they act unethically in their capacity as business rescue practitioners, and the Legal Practice Council has been very, very slow to act on complaints against their members when they are acting as business rescue practitioners. But be that as it may, the Legal Practice Council is such an accredited professional body. The other qualifications for appointment as a business rescue practitioner are really more like disqualifications. In other words, instead of saying you must comply with these requirements, it says you may not be any of the following. And there was, in fact, a judgment where the court said it's a pity that the drafters were, I don't think they used the word lazy, but it came down to that they were too lazy to draft specific qualifications for a business rescue practitioner and decide on what would be the important qualities of a business rescue practitioner. So instead, what they did was they simply borrowed from the qualifications for appointment as a director, which is not really the same thing, and they don't always apply correctly. But anyway, that's what we stuck with. So although Section 138 states that a person may be appointed, and the definition of person includes a legal person, you will see when you look at the other qualifications or disqualifications that a legal person cannot be appointed. It must always be a natural person. Okay, so there are 6 qualifications, and the CIPC may withdraw or suspend your license. For example, when failing to submit your monthly progress reports, which we'll talk about later, then the practitioner no longer meets the requirements of Section 138. The problem with that is that you do not automatically stop being the business rescue practitioner in a case where you've been appointed. Somebody has to go to court and have you removed in terms of Section 138 because you are no longer licensed. So it should have been possible to suspend the license. Obviously, you cannot take any further appointments once your license has been suspended, but it's not at all clear whether you can continue with cases where you have already been appointed. Okay. The restriction on practice, you must remember that in this Act, and specifically Chapter 6, the regulations are just as important as the sections of the Act, because the drafters have sort of hidden away quite important provisions in the regulations where you would have expected this to be as sections in the Act. So what this basically states is that all licensed practitioners are classified based on their period actively engaged in business turnaround practice. That is defined, but it's actually no longer necessary. That was to provide for the period before the Act had been in force for 10 years. So to be a senior practitioner, you must have at least 10 years practice or experience. But if business rescue had not been in force or available for 10 years, then you could prove other activities which fell within the definition. Now the CIPC will basically look at appointment and activities as a business rescue practitioner for at least 10 years, and then you are a senior practitioner. You can be appointed for any company, including state-owned companies. Experienced practitioner has at least 5 years experience, can be appointed for a medium or small company, but not a state-owned company, and not a large company. And then a junior practitioner, that's somebody with less than 5 years or no experience, only small companies, except as assistant to the practitioner. And the classification of companies is done by way of their public interest score. So when you apply or when you submit your a notice of appointment as a business rescue, no, I think actually it's when the company files its notice of commencement of business rescue, the resolution, they must, among other things, declare the public interest score of the company so that the CIPC can decide whether your practitioner meets the requirements for appointment of that company, because it's the CIPC that that classifies practitioners as senior, experienced, or junior. So they will check that. Sometimes some practitioners slip through the cracks and they get appointed in companies for which they are not qualified. But the CIPC has undertaken to be much more careful about that in future. So the other qualifications, as I said, they're more disqualifications than qualifications. You must not be subject to an order of probation. Now, normally for a director, that period is only 5 years and it can be limited to specific companies, but there's no indication of this limitation to business rescue practitioners. So apparently any order of probation will disqualify you. Must not be disqualified from acting as a director. So there's a difference between disqualification and ineligible. So obviously a person who is ineligible, a juristic person and a minor, cannot be appointed as business rescue practitioner, but you are disqualified also if you have been declared delinquent, you're an unrehabilitated insolvent, or you have been removed from an office of trust. You can look that up in the Act and in your textbook. I don't have to tell you that. Then you must be independent from the company, and you must not be related to a person with such a compromising relationship. Now, unfortunately, the drafters did not say directly you must be independent from the company. They chose a very convoluted wording that you must not have any other relationship with a company that may lead a reasonable person to think that you have some other. It's some terrible, terrible wording, which in the end led to a few appointments that were very questionable. But because of this wording, the court in one case said, well, they can't see a problem with the appointment of a business rescue practitioner who has been acting as an attorney for the company in business rescue, and in this instance had acted for the company in litigation against the major creditor of the company. And the court said, well, there's no indication that it would lead a reasonable person. There's no evidence of unethical or independent activities. So it's fine to appoint this attorney as business rescue practitioner. The attorney, of course, should have refused the appointment, but he didn't. And in the end, the company ended up in liquidation anyway. Right. A quotation from the 2022 Deloitte restructuring survey, where they said what is evident is that there is a widening trust gap between practitioners and their stakeholders. Low success rates experienced, especially by lenders, contribute to this. The suitability of the business rescue practitioner is also rated as one of the main reasons that business rescue fails, ranking closely behind a lack of post-commencement financing as a cause of failure. So, and then one business rescue practitioner said, the problem is that many business rescue practitioners lack the skill and ethics to do it properly, because there's no actual requirement that you must undergo some training. It's just that if you're a junior practitioner, you're supposed to sort of learn it on the job while doing it. Right. Then, oops, no, this is not what I wanted to do. Next slide. Removal of the practitioner. As I said before, the only way you can remove a practitioner is by order of court, except for that one instance where the interim practitioner appointed by the court, when a business rescue order is issued, if the independent creditors refuse to ratify that agreement, then the practitioner is automatically removed. But otherwise, you always have to go to court. Now, there are two sections that deal with this. The one is section 130, which we've already talked about. That's where the practitioner was appointed by the board after filing a business rescue resolution with the CIPC. In both cases, only affected persons may apply, and unfortunately not the CIPC. So although the CIPC often gets complaints from affected persons about the unethical and unacceptable behavior and actions of business rescue practitioners, they do not have the authority to apply to court for the removal of a practitioner. All they can do is suspend their license, but then somebody else still has to apply to court for removal. Okay, so Section 130 applies if the practitioner was appointed by a board resolution, but you can only use this until the business rescue plan has been approved. After that, Section 130 falls away. So you can do it on 3 specific grounds, which is that the practitioner does not meet the Section 138 requirements that we've just talked about, or is not independent of the company or management. So this is the first time management is mentioned, because under the requirements, it was only required that he must be or she must be independent of the company. And then on the grounds that he or she lacks the necessary skills for that particular company. Again, this is not a requirement for appointment, but it is you can base your application for removal on that business rescue practitioner. I just want to have a look here.